My name is Bumgardner, president of Xpera Group. I think we may now be the largest group of construction experts in San Diego County. We have offices in Solana Beach and Rancho Bernardo, and about 40 experts in our program. We do all kinds of things: construction management, quality assurance, this forensic stuff. We get involved in everything from accidents to delay claims to property loss to defects litigation. I want to talk about a couple of things real quick. I want to talk about one would be what I see as from an expert perspective, a major impediment to resolution that I think we need to be aware of and think past as an industry. And the other thing I want to talk about is some very specific tips on how to buy right when you're buying expert services. Start out with, I want to talk about this as an impediment to resolution, the advocate expert. Advocate experts cost the litigation business, cost this whole process a tremendous amount of money. Technical experts who buy into this concept that they have to go well beyond conventional reason in order to get the best result for their client actually don't get the best result for their client. And to compound that problem, a lot of attorneys you talk to will of course say, no, I want an expert that calls it like he sees it. But really that attorney is looking for an expert to call it like the attorney wants the expert to call it for the benefit of his client when it comes right down to it, right? I look around the room to make sure I don't tell any stories on anybody that is here, so I'll talk about people that aren't. I had a well-known plaintiff attorney come to my office, and I spent a fair amount of time describing how we do this great job of cost estimating, and we have all this great data in our work in reconstruction, how we know what this stuff costs. And he looked me right in the eye and said, I don't really care about what you think it actually costs. All I care about is, can you get me big numbers? And I don't know how, I told him I can't help you there. It is what it is. So there's this pressure in the industry for experts to be advocates. Most attorneys recognize, though, that what they really want is an expert that's an advocate that doesn't act like an advocate or come across as an advocate, because they know that can turn other people off. But so how do you reconcile that, right? Most people aren't really persuaded by people who are obvious advocate experts, and like I said, they totally don't help the process. So I want to talk for a moment. I'm going to go a little off tangent here and tell a little quick story, and then we're going to come back around to how you reconcile that and how experts should handle that. My little story I want to tell you about. About 12 years ago, I had one of those aha moments. You know, I've been in the consulting business for, I don't know, 25, maybe 30 years. And as a construction manager, as an expert in all these things, about 12 years ago, I had one of those aha moments. I was flying from San Diego to Dallas, and one of those flights that stopped in El Paso briefly to let off passengers and get on passengers. I headed to Dallas on a big case I was involved in. Anyway, a guy sits down next to me. And I'm done with my reading, and I'm taking a look and kind of trying to figure him out. And I play this game on airplanes. I always try to figure out, what does the person do for a living that's sitting next to me, right? And I felt like striking up a conversation. This young man was had the high, the tight, high and tight haircut, aviator glasses. He was built really well, leather jacket. Had laying next to him a magazine, Guns and Ammo magazine, and a law enforcement magazine. This guy looked like he was a cop. He could be FBI. I don't know. I mean, he was obviously in law enforcement. So I struck up a conversation. I said, so how long have you been in law enforcement? He goes, I'm not in law enforcement. So what do you do? He said, I'm a computer programmer. And I'm thinking, wow, they don't look like that out on the West Coast. That's kind of odd. Texas must have its own breed of computer programmers. They must be packing heat to program computers in Texas. So they've struck up a conversation. Come to find out, this guy was a computer programmer. He had developed a program that tracked criminals through the criminal justice system. He had been in El Paso for a couple weeks implementing this program to the sheriff's department, the police department, the feds, etc. And from this conversation, I came to learn this guy, he's a computer programmer, but he hung with cops. His friends were all in law enforcement. He read law enforcement magazines. He was very interested in law enforcement. So here's the aha moment. he was probably a pretty good computer programmer. He had been extremely successful. He had his own business and he developed these systems. He sold all over the country. I'll bet you he was very successful not because he was some brilliant computer programmer, but because he had empathized with his client. He understood his client's perspective. And by understanding his client's perspective, he could apply technology for the benefit of that client. So the brilliance in technology has no real value in itself. The value in technology comes from our ability to apply technology to the needs of people who aren't technical. Wow. That was an aha moment. I went back to our company in San Diego. At that time, I was vice president of a very large construction management company. We took a look at our project managers and projects we'd been involved in for years, and we used to always talk in terms of some project managers got it and some just didn't get it, and some projects were very successful and some projects weren't so successful. But then we took a real hard look at what makes them work and what makes them doesn't work. The project managers who had been able to empathize with their clients, who mentally and figuratively sat on the same side of the table as their clients and saw the world through their clients' eyes, were way more successful at being project managers. And not only that, when problems did come up, they were better able to understand the client's perspective and bring the right solution to the table. And most importantly, when problems came up, they were perceived by the client to be a part of the solution and not a part of the problem. It became one of our core values of the construction management business, this empathy thing, right? And we then went on to become, over the next few years, we became within the top 50 largest CM companies in the country. All right, so what does all this touchy-feely empathy stuff have to do with experting anyway? Those of you who are old enough to remember Dragnet, you know, in the famous line by Sergeant Friday, just the facts, ma'am, right? They would be listening to some woman go off on some tangents and just the facts, ma'am. Well, experting business, it's supposed to be this dispassionate business where experts are, where they're not caught up in the whose side is what, etc., and they just evaluate the facts and what have you. But this empathy thing is absolutely critical to becoming a good expert, and here's why. Jurors make decisions not on what they see, not on what they hear, but on what they see and hear that they believe. An expert who has good empathetic skills can put himself into the shoes of a non-technical person and make the technical information simple to where a non-technical person, a decision maker, can understand it. And that is really the heart of what an expert is really there to do. We are there to understand all this technical crap and then to make it bonehead simple for attorneys, for triers of fact, for decision makers, for mediators, for insurers, claims managers, etc. Our job is to take this complicated stuff and make it simple. The way you make that simple for non-technical people is first you have to understand from a non-technical person's perspective. Many experts are so wrapped up in their own technical world that they lose sight of the fact that their opinion really doesn't matter. It really doesn't. It's only the opinion of that housewife or shopkeeper on the jury. That's the opinion that matters, not the technical guy's opinions. So as a technical expert, we have to be able to make this complicated stuff simple. But as someone pointed out earlier, few cases ever really get to trial. They mostly get resolved in mediation. The ability to see from someone else's perspective is absolutely critical to the mediation process. In mediation, good experts don't go there to horse trade ideas or to be so wrapped up in their own opinion that they can't hear anyone else's opinion but for their own and lock and load. And good experts go to mediation to truly try to understand the other expert's perspective. Good experts go to mediation to listen first and talk second. Okay? And a good expert who is able to empathize and understand the perspectives of others can then use that understanding to then tee up his own data and information in a way that the other side can understand it. And then, because the mediation process is about resolution, but it's also about sizing up the other side. A good expert is able to come to mediation and present the information in such a way that it is so bonehead simple and seems like just good, logical, common sense. And few things are scarier to an opposing counsel than an expert who presents this technical stuff so simply that they go, crap, the jury's going to get that. They're going to buy into that. And so as an expert, it's not our place to make it more complicated. It's our place to make it simple and use good common sense and listen first. And I think a lot of experts lose sight of that fact. So, how do we hire the best expert and control costs? Someone was talking a while ago about how the business is changing and we're moving more into other types of litigation. And early on, I think Ed in his opening comments mentioned that, you know, we all make a living here. A lot of us make a living here out of, in part anyway, residential litigation. Well, we talk about these things affecting the world and affecting the world of residential litigation, whether it be the newest statute or whatever. There's something going on right now that is going to have a huge impact on basic defects litigation. I'm going to quote you a statistic from California, and I haven't run the numbers on other states, but the numbers run fairly similarly. Take this into consideration. In the next 4 years, the number of homes that are eligible to litigate under a 10-year statute in the state of California will have decreased 75% from their peak in 2007. Now, in the state of California, during this recession that we've been through, approximately half of the people working in construction are no longer working in construction. The construction market shrunk that much. Think about the cases you have in your own firms right now. We're still litigating the boom, folks. Most of this product was built by 2007. So we're still litigating the boom. If you consider the typical time from closing on the sale to when it shows up in litigation and it's in our process, we're still way back there. But in the few years to come, that's going to change dramatically. And as George Calkins said a while ago, we're seeing the same thing. We're seeing a lot of movement, a lot of things happening in other areas of litigation, but nothing's really going to replace that elephant in the room, which is all of this residential litigation. So what's going to happen is we all have to be smarter, we all have to be more cost efficient, and we all have to bring more value to our clients if we're going to survive. So how do we do that? You need to hire experts who are skilled at resolution. How do you tell whether an expert is going to be one of these advocate experts and a fist pounder that's intransigent and locked in their position and hurt the process? Well, you need to evaluate right up front. Do they listen very well? Does the expert rush to opinion? If he's telling you his opinion about your case before you've told him about the case, he's probably the wrong expert, right? And if he's if he's way more interested in his opinions than your case, then he's really not the right expert. So you got to keep an eye out for that. Another thing is if an expert criticizes the other side before he's ever even heard where they came from, he's probably not very skilled at all that. Hire the right level of expert. Hiring an expert, you know, I think about this. Hiring an expert, most attorneys go about hiring an expert like someone goes about buying a pickup truck. You may haul your boat to the river twice a year, but you're going to go down and buy a new pickup truck, and in spite of the fact that you drive to the office, haul kids to school, and stop for groceries, you know, the other 50 weeks of the year, twice a year you haul your boat to the river, but you're going to buy a pickup truck to tow your boat, right? Well, the majority of cases settle way short of litigation or short of trial, but there's a tendency to hire the expert that's going to be the good trial testifying expert. There's basically two categories of experts, quite frankly. There are those that are very technically competent, but they wouldn't hold up well under cross-examination. They're not going to present well at trial. Those are typically the support experts, the support folks in a shop like ours, for example, where we have lots of folks. Those are the support people. And then you have another type of expert that's the testifying expert, the one who can go to trial and carry it off, hold up under cross-examination very well, and be the testifying expert. The reality is one's about twice as expensive as the other. But not every case needs a testifying expert from day one. We talk about SB 800 and that's a pre-litigation process. That can very well be handled often by those evaluations by something short of a testifying expert and a lot of savings. You need to help your expert be successful. You know, as someone said a while ago, well, you get an expert into a case and most experts already know what they got to do. Well, that's probably true in most very standard, typical residential litigation cases. But there's a lot of cases out there that are quite different than that. And as an expert, understanding my assignment, understanding the box I'm in is critical to me being cost effective and critical for me being able to carry it off for you. A lot of attorneys want to hold off till the very last minute before they start articulating assignment. You need to do that early. You need to work with your expert to develop a budget. And that's not just say, expert, give me a number so I can pass it on to the carrier so we're covered. I mean, you need to work with your expert to develop a budget. Talk through the process. Talk through all the elements of the process and come to a very succinct budget based on a common understanding between you and the expert of the level of effort, and then you'll have something that means something. On large, complex cases, we have found that we can save a lot of money by fielding a team. The majority of our defects cases these days, we do a lot of wrap-up coverage type things. We field the entire team, and we've been able to save a lot of money by having a coordinated, managed team with a common set of documents that, as opposed to a whole scattering of separate experts cobbled together. Single-point case management and administration. The bottom line for protecting your bottom line when it comes to working with experts on construction litigation is working with the right expert team in the first place. And I will pass on to